We're live. Contracts and sales. What is a contract and what law applies? A contract is a promise or set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes a duty. It is simply a legally enforceable agreement, but keep in mind that just because the two parties have an agreement doesn't mean that it's legally enforceable. We need to have an agreement plus something more that makes it legally enforceable. Typically, that's going to be consideration or a substitute for consideration, both of which we'll talk about in Module 3. Types of contracts. Express contracts are formed by language, oral or written. Implied contracts are formed by conduct. Quasi-contracts are not contracts at all. Quasi-contract is the name when an unenforceable contract results in unjust enrichment. Courts permit a plaintiff to bring an action in restitution to recover the amount of the benefit conferred on the defendant. This is discussed further in the remedies module. There's a table for express, implied, and quasi-contract, if you didn't know, but I'll read quasi-contract one more time. One party is unjustly enriched at the expense of the other party so that the enriched party must pay restitution to the other party equal to the unjust enrichment. Part 1.1.1 as to acceptance. Bilateral contracts, exchange of mutual promises. A bilateral contract is one consisting of the exchange of mutual promises, that is, a promise for a promise. Each party is both a promisor and a promisee. A bilateral contract offer can be accepted in any reasonable way. Most contracts are bilateral, which means that most offers are indifferent offers that may be accepted by promising or beginning performance unless expressly indicated otherwise. Assume any contract is a bilateral contract. Unilateral contracts, acceptance by performance. A unilateral contract is one in which the offerer requests performance rather than a promise. Here, the offerer, promisor, promises to pay upon the completion of the requested act by the promisee. Once the act is completed, the contract is formed. Occurs in only two situations: when the offerer clearly, unambiguously indicates that completion of performance is the only manner of acceptance, and two, where there is an offer to the public, such as a reward offer. Part 1.1.1 as to validity, void contract, voidable contract, and unenforceable contract. A void contract is one that is totally without any legal effect from the beginning. For example, an agreement to commit a crime. It cannot be enforced by either party. A voidable contract is one that one or both parties may elect to avoid, such as by raising a defense that makes it voidable, like infancy or mental illness. An unenforceable contract is otherwise valid but isn't enforceable due to a defense, such as the statute of limitations or statute of frauds. Page 4. Common law versus Article 2 sale of goods. Generally, the common law governs contracts. However, for contracts involving the sale of goods, Article 2 of the Uniform Commercial Code applies. Article 2 has adopted much of the common law of contracts, but when the common law and Article 2 differ, Article 2 governs in a contract for the sale of goods. Goods defined. Goods are all things movable at the time they are identified as the items to be sold under the contract. Thus, Article 2 applies to sales of most tangible things, including cars, horses, hamburgers, but doesn't apply to the sale of real estate services, such as a health club membership, or employment, or intangibles, such as a patent, or to construction contracts. Merchants versus non-merchants. A number of the rules in Article 2 depend on whether the seller and or buyer are merchants. Article 2 generally defines merchant as one who deals regularly in goods of the kind sold or who otherwise by their profession holds themselves out as having special knowledge or skills as to the practices or goods involved. Article 2 provisions dealing with general business practices, for example, statute of frauds, confirmatory memos, firm offers modification, almost anyone in business can be deemed a merchant. But remember that some Article 2 provisions, for example, the implied warranty of merchantability, are narrower and require a person to be a merchant with respect to the goods of the kind involved in the subject transaction. Contracts involving goods and non-goods. If a sale involves both goods and services, you will determine which aspect is dominant and apply the law governing that aspect to the whole contract. However, if the contract divides payment between goods and services, then Article 2 will apply to the sale portion and the common law will apply to the services portion. Wrong. There's a predominant purpose test, actually, that you'll go through. So that's wrong. Thanks. Good faith and fair dealing. Every contract within the UCC composes an obligation of good faith in its performance and enforcement. Good faith is honesty in fact and the observance of reasonable commercial standards. The common law also imposes a duty of good faith and fair dealing. A breach of this duty usually involves exercising discretion in a way that deprives the other party of the fruits of the contract. Is this contract? Oh, this is contracts right here. So the predominant purpose test is in the UCC, and I actually bookmarked it. It's on page 28 for mixed transactions. There's also the gravamen test on page 29, so these aren't very long sections. For such transactions, so basically Article 2 does not apply to transactions that involve purely real estate and services. However, some transactions can involve a combination of goods and services, as in a contract to sell goods and provide maintenance services for a specified period of time, or goods and real property, as in the sale of a business that owns both real and personal property. Such transactions are commonly referred to as mixed or hybrid transactions, and the general rule based on case law is that you must determine what aspect of the transaction predominates. Specifically, after you determine that there is a contract involving both goods and services, you must decide whether the contract's predominant factor is 1, providing services with goods incidentally involved, such as a contract with an artist to paint a painting, or 2, to sell goods with labor incidentally involved, for example, a contract for the sale including installation of a stove. This test essentially involves consideration of the contract in its entirety, applying the UCC to the entire contract or not at all. So, alternatively, for mixed transactions, there's a gravamen test. A small minority of U.S. courts have formulated the gravamen test as an alternative test for determining the applicability of Article 2 in a mixed contract involving both goods and services. This test seeks to determine whether the aggrieved party is complaining about the quality of the services rendered or the quality of the goods delivered. If the complaint is about the goods, then Article 2 will govern the analysis. If the complaint is about the services, the rules of common law contracts will apply instead. Other scope analysis is policy grounds. They will use Article 2 rules stating that the transaction before the court is analogous to a goods sales transaction, and that the Article 2 rules are therefore helpful to apply. So it will tell me that in any event that you would quote, however, if the contract divides payment between goods and services, then Article 2 will apply to the sale portion and the common law will apply to the services portion. Wrong. That's not what you would do. Article 2 either applies or it doesn't. You go through a predominant purpose test or a gravamen test in the minority of jurisdictions. Thanks. Mutual assent, offer, and acceptance. For an agreement to be enforced as a contract, there must be mutual assent. In other words, one party must accept the other's offer. Whether mutual assent is present will be determined by an objective standard. That is, did words or conduct manifest a present intention to enter into the contract? When a suit is brought in which one party seeks to enforce a contract or to obtain damages for a breach of contract, a court must first decide whether there was in fact a contract. In making this determination, the court will ask the following three questions. Was there mutual assent? Was there consideration or some substitute for consideration? And were there any defenses to the creation of the contract? What I've learned also is that we need to be concerned with, is there authority to enter into a contract if you're talking about partnerships or corporations, or even legal client relationships. An offer creates a power of acceptance. This is the offer section. Actually, I skipped a really big table on the last page, didn't I? The table is the elements of the contract, and it shows first mutual assent, then consideration, then no defenses. So for mutual assent, you have an offer and an acceptance. An offer, and this might be a good slide for note cards. So an offer is probably going to be defined as, promise, undertaking, or commitment with definite and certain terms communicated. To the offeree, the acceptance before termination by revocation, rejection, or operation of law. It's not really a definition, but it does have two different definitions. Acceptance under, I did take notes on this. Actually, my notes on this say that the common law follows the mirror image rule, where acceptance must be identical to the terms of the offer, whereas the UCC has honors this battle of the forms contention. Any communication showing assent to the deal would be acceptance, even if the forms contain non-reflexive terms. Consideration, bargain for exchange of something of legal value, is part of the consideration, and substitute for consideration such as promissory estoppel, detrimental reliance, or good faith modification under the UCC. Interesting. Okay, so for no defenses, the types that we're talking about in this table, in this visual, is mistake, lack of capacity, and illegality or statute of frauds. There's no definition for statute of frauds. Illegality usually renders a contract void. Lack of capacity makes a contract void or voidable. Mistake, mutual or under certain conditions unilateral. For instance, if one party knew that the other party was mistaken and could have, but didn't clarify for the mistaken party, then the party who's mistaken to their detriment may be released from the contract by rescission. There could be more going on there, and hopefully we read on about it. The offer. An offer creates a power of acceptance in the offeree and a corresponding liability on the part of the offerer. For a communication to be an offer, it must create a reasonable expectation in the offeree that the offerer is willing to enter into a contract on the basis of the offered terms. In deciding whether a communication creates this reasonable expectation, ask, was there an expression of a promise, undertaking, or commitment to enter into a contract? Were there certainty and definiteness in the essential terms? Was there communication of the above to the offeree? Promise, undertaking, and commitment. For a communication to be an offer, it must contain a promise, undertaking, or commitment to enter into a contract rather than a mere invitation to begin preliminary negotiations. That is, there must be an intent to enter into a contract. Additionally, the certainty and definiteness of essential terms in a communication of the above to the offeree. That's what the offer consists of. I like that too. Language. The language used may show that the offer was or was not intended. Technical language such as I offer or I promise is useful, but it isn't necessary. Phrases such as I quote, I am asking $30 for, and I would consider selling for tend to be construed merely as invitations to a deal rather than offers. Surrounding circumstances. The circumstances surrounding the language is considered by the courts in determining whether an offer exists. For example, if a statement is made in jest, anger, or by way of bragging, and it is reasonably understood in this context, it will have no legal effect. Prior practice and relationship of the parties in determining whether certain remarks constitute an offer rather than preliminary negotiations, a court will look to the prior relationship and practice of the parties involved. Method of communication. So prior practice and relationship of the parties I just read after surrounding circumstances. I think that in that section it should be added that the subjective intent isn't relevant. It's would a reasonable person objectively understand from the circumstances that an offer exists. In prior practice and relationship with the parties, the court may look to the prior relationship and practice of the parties to determine if the remarks constitute an offer rather than preliminary negotiations. Now, for method of communication, use of broad communication media. The broader the communication media, for example, publications, the more likely it is that the courts will view the communication merely as a solicitation of an offer. Advertisements, catalogs, circular letters, and the like containing price quotations are usually construed as mere invitations for offer. Definite and certain terms. An offer must be definite and certain in its terms. The basic inquiry is whether enough of the essential terms have been provided so that a contract including them is capable of being enforced. Identification of the offeree. To be considered an offer, a statement must sufficiently identify the offeree or a class to which they belong to justify the inference that the offerer intended to create the power of acceptance. Okay, that's a definite and certain terms. Identification of the offeree. Because, you need certain and definite terms for the judge to enforce them. Secondarily, the definiteness of the subject matter entails that the subject matter of the deal be certain, because a court can enforce a promise only if it can tell with reasonable accuracy what the promise is. So requirements for specific types of contracts are real estate transactions, sale of goods, and employment and other services. So that minimum requirement for real estate transactions is the land and price terms. An offer involving realty must identify the land and the price terms. The land must be identified with some particularity, but a deed description isn't required. For example, my house in city name is sufficient for the seller. If they have only one house in that city, most courts will not supply a missing price term for realty. For the sale of goods, the quantity term is essential. So in a contract for the sale of goods, the quantity being offered must be certain or capable of being made certain. So requirements and output contracts are kind of an exception to that. So in a requirements contract, the buyer promises to buy from a certain seller all of the goods the buyer requires, and the seller agrees to sell that amount to the buyer. In an output contract, the seller promises to sell to a certain buyer all of the goods that the seller produces, and the buyer agrees to buy that amount from the seller. It is assumed that the parties will act in good faith, so there can't be a tender of or a demand for quantity unreasonably disproportionate to 1, any stated estimate, or 2, in the absence of a stated estimate, any normal or otherwise comparable prior output or requirement. So lastly, employment and other services and contracts for employment. If the duration of the employment is not specified, the offer, if accepted, of the employment is not specified, the offer, if accepted, is construed as creating a contract terminable at the will of the other party. For other services, the nature of the work to be performed must be included in the offer. Missing terms. The fact that one or more terms are left open does not prevent the formation of a contract if it appears that the parties intended to make a contract and there is a reasonably certain basis for giving a remedy. In such a case, the majority of jurisdictions in Article 2 hold that the court can supply reasonable terms for those that are missing. Price. Except in contracts for real property, the failure to state the price doesn't prevent the formation of a contract if the parties intended to form a contract without the price being settled. Note that if a contract for the sale of goods is missing a price term, Article 2 provides that the price will be a reasonable price at the time of delivery. Time. If an agreement doesn't specify the time in which, let's get to the end of this, act is to be performed, the law implies that it is to be performed within a reasonable time. And so that was the section making up missing terms. I'm just going to read the bold parts one more time. In contract, the fact that one or more terms is left open does not prevent formation of a contract if it appears that the parties intended to make a contract and there is a reasonably certain basis for giving a remedy. In such a case, the majority of jurisdictions and Article 2 hold that the court can supply reasonable terms for those that are missing. And price and time were discussed in that section. Then there's vague terms. The presumption that the party's intent was to include a reasonable term goes to supplying missing terms. The presumption cannot be made if the parties have included a term that makes the contract too vague to be enforced. For example, an agreement to split profits on a liberal basis. However, uncertainty can be cured by part performance that clarifies the vague term or by acceptance of full performance. And lastly, terms to be agreed on later. Often an offer will state that some term is to be agreed on at a future date. If that term is a material term, the offer is too uncertain. In communication to offeree. To have the power to accept, the offeree must have knowledge of the offer. Therefore, the proposal must be communicated to them. Termination of offer. An offer can't be accepted after it has been terminated. An offer may be terminated by an act of either party or by operation of law. Termination by acts of parties. Termination by offeree. Lapse of time. An offer may be terminated by offeree's failure to accept within the time specified by the offer, or if no deadline was specified within a reasonable period. That's lapse of time. And a termination by the offeree. Rejection. Express rejection and counteroffer as rejection. An express rejection is a statement by the offeree that they do not intend to accept the offer. Such a rejection will terminate the offer. Counteroffer as rejection. A counteroffer is an offer made by the offeree to the offeror that contains the same subject matter as the original offer but differs in its terms. For example, I'll take the house at that price, but only if you paint it first. And so, distinguish mere inquiries from counteroffers. So distinguish between a counteroffer, which constitutes a rejection, and a mere inquiry. An inquiry won't terminate the offer when it is consistent with the idea that the offeree is still keeping the original proposal under consideration. For example, would you consider lowering your price by $5,000? The test is whether the reasonable person would believe that the original offer had been rejected. Conditional acceptance as rejection. When an acceptance is made expressly conditional on the acceptance of new terms, it is a rejection of the offer. The conditional acceptance is essentially a new offer, and the original offerer may form a contract by expressly assenting to new terms. However, the offer that results in from a conditional acceptance cannot be accepted by performance if the parties ship or accept goods. After conditional acceptance, the contract is formed by their conduct and the new terms are not included. Effective when received. A rejection is effective when received by the offeror. Rejection of an option. As an option is a contract to keep an offer open. A rejection of a counteroffer to an option does not constitute a termination of the offer. The offeree is still free to accept the original offer within the option period unless the offeror has detrimentally relied on the offeree's rejection. Termination by offer or revocation. A revocation is a retraction of an offer by the offeree. An offeror may revoke or the offeror may revoke. Oh, did I say him? A revocation is a retraction of an offer. An offeror may revoke by directly communicating the revocation to the offeree. For example, I revoke my offer of May 25th. An offer made by publication can be directly revoked by only by publication through comparable means. For example, an offer placed in the Wall Street Journal cannot be revoked by publishing in Better Homes and Gardens. An offer may also be revoked indirectly if the offeree receives 1. Correct information, 2. From a reliable source, 3. Of acts of the offerer that would indicate to a reasonable person that the offerer no longer wishes to make the offer. For example, after the offerer offers to sell their car to the offeree is told by a reliable third party that the offerer just sold the car to someone else. Effective when received. A revocation is generally effective when received by the offeree. The revocation is by publication. Is that an if? Where revocation is by publication, it is effective when published. Okay. Limitations on the offeror's power to revoke. Offers can be revoked by will by the offeror, even if he has promised not to revoke for a certain period, except in the following circumstances. And you have options. An option is a distinct contract in which the offeree gives consideration for a promise by the offeror not to revoke an outstanding offer. For example, an offeror offers to sell our farm to an offeree for $1 million and promises to keep the offer open for 90 days. If the offeree pays the offeror $1,000 to keep the offer open. Merchant's firm offer under Article 2. Article 2. If a merchant, so these are the elements. 1, if a merchant, 2, offers to buy or sell goods in a signed writing, and 3, the writing gives assurances that it will be held open. For example, this offer will be held open for 10 days. This offer is firm for 10 days, or I shall not revoke this offer for 10 days. The offer is not revocable for lack of consideration during the time stated, or if no time is stated for a reasonable time, but in no event may such period exceed 3 months. Detrimental reliance. When the offerer could reasonably expect that the offeree would rely to their detriment on the offer, the offeree does so rely. The offer will be held irrevocable as an option contract for a reasonable length of time. Page 18. Beginning performance in response to true unilateral contract offer. An offer for a true unilateral contract becomes irrevocable once performance has begun. The offeror must give the offeree a reasonable time to complete performance. Note that the offeree is not bound to complete performance. They may withdraw at any time prior to completion of performance, and there is no acceptance until performance is complete. Distinguish preparations to perform. Substantial preparations to perform as opposed to the beginning of performance. Do not mistake the offer irrevocable do not make the offer irrevocable, but may constitute detrimental reliance sufficient to make the offerer's promise binding to the extent of the detrimental reliance. Beginning performance. Offer indifferent as to manner of acceptance. As noted above, most offers are different as to the manner of acceptance, and thus a bilateral contract may be formed upon the start of performance by the offeree. Therefore, once the offeree begins performance, the contract is complete and revocation becomes impossible. But note, notification of the start of performance may be necessary. Termination by operation of law. The following events will terminate an offer by operation of law: death or insanity of either party. Unless the offer is of the kind of the offerer would not terminate, such as an option supported by consideration, death or insanity need not be communicated to the other party. Destruction of the proposed contract subject matter or supervening illegality. So those are terminations by operation of law. Death or insanity of either party, unless the offer is the kind the offerer could not terminate, such as an option supported by consideration. Death or insanity not be communicated to the other party. Destruction of the proposed contract subject matter or supervening illegality. So as for death, we're still talking about offers. So it's just an offer. We're not talking about an executed contract. When is it effective? It's effective when the death or insanity of either party, the destruction of the subject matter, or supervening illegality occurs. What's the methods? I just read all three of them twice. Now, in terms of terminating an offer by rejection by the offeree, when is this effective? It's effective when received. If it's and that is the same for rejection by an offeree. So offerer, offeree rejections, those are effective when they're received. How? A revocation by an offerer has to be express or implied. For example, the offeree discovers the offerer sold subject matter to someone else in the implied, if it's of the implied kind. Whereas rejection by offeree, this must be an express rejection, a counteroffer, or a lapse of reasonable time. Limitations on the power to terminate as it relates to the offerer: an option contract, merchant's firm offer, detrimental reliance, or beginning performance on a unilateral contract can limit the power to terminate. Whereas rejection by offeree generally cannot reject if already accepted. That's your limit on the power to terminate. Moving on to page 20. I wonder if I ever get out of module 1. Probably not. They're still in module 1. Module 2, the acceptance. An acceptance is a manifestation of the assent to the terms of an offer. Who may accept? Generally, only the person to whom the offer is addressed has the power of acceptance. A member of a class to which an offer has been directed also has the power to accept. Generally, an offeree's power of acceptance cannot be assigned, but if the offeree paid consideration to keep the offer open, an option contract, the right to accept is transferable. Offeree must know the offer. The offeree must know of the offer in order to accept it. And this is true whether the offer is for a bilateral or unilateral contract. Thus, if A sends B an offer and B sends A an offer, unaware of A's offer, such as crossing after situation, no contract is formed, even if the offer contained the same terms. Nope, nothing to say about that. Acceptance of offer for bilateral contract. Recall that unless the offer specifically provides that a person that it may be accepted only through performance, it will be construed as an offer to enter into a bilateral contracted may be accepted either by a promise to perform or the beginning of performance. Acceptance must be communicated. Unless the offer provinces otherwise, acceptance of an offer to enter into a bilateral contract must be communicated to the offerer. Silence as acceptance. Generally, the offerer can't be forced to speak or have their silence treated as acceptance. However, a court may find silence works as an acceptance if, because of the prior dealings of the trade parties, it would be commercially reasonable for the offerer to consider silence as acceptance. Also, if the recipient of services knows or should have known that the services were being rendered with the expectation of compensation and by a word could have prevented the mistake, the recipient may be held to have accepted the offer if they fail to speak. Methods of acceptance. Unless otherwise provided, an offer is construed as inviting acceptance in any reasonable manner and in any medium reasonable under the circumstances. Any objective manifestation of the offer's compromise is usually sufficient. Offers to buy goods for current or prompt shipment. Under Article 2, an offer to pay goods for current or prompt shipment is construed as inviting acceptance either by a promise to ship or by current or prompt shipment of conforming or non-conforming goods. Acceptance must be unequivocal. Traditional contract law insists on an absolute and unequivocal acceptance of each and every term of the offer. Mirror image rule. At common law, any different or additional term in the acceptance make a response, a rejection, and counteroffer. Acceptance of offer for unilateral contract. If an offer provides that it may be accepted only by performance, that is an offer for unilateral contract, note the following particular rules. Completion of performance. A unilateral contract is not accepted until performance is completed. Recall that beginning of performance may create an option so that the offer is irrevocable. However, if the offeree is not obligated to complete performance, merely because they have begun performance, as the complete performance constitutes an acceptance of the offer. Just doing a time check. 37 minutes. I'm on page 22 of the CMR. In Module 2, notice. Generally, the offeree is not required to give the offerer notice that he has begun the requested performance, but is required to notify the offerer within a reasonable time after performance has been completed. However, no notice is required. 1, if the offerer waived notice, or 2, the offeree's performance would normally come to the offerer's attention within a reasonable time. Acceptance under Article 2, which is different than the common law we just went into. Offers to buy goods for current or prompt shipment. As noted above, an offer to buy goods for current or prompt shipment may be accepted by either a promise to ship or by a shipment of conforming or non-conforming goods. Shipment of non-conforming goods. The shipment of non-conforming goods is an acceptance creating a bilateral contract as well as a breach of the contract unless the seller seasonably notifies the buyer that the shipment of non-conforming goods is offered only as an accommodation. The buyer is not required to accept accommodation goods and may reject them. If the buyer rejects, the shipper isn't in breach and may reclaim the accommodation goods because the tender does not constitute an acceptance of the buyer's original offer. Battle of the Forms provision. Mirror image not required. Article 2 has abandoned the mirror image rule, providing instead that the inclusion of additional or different terms by the offeree in a definite and timely acceptance does not constitute a rejection and counteroffer, but rather is effective as an acceptance unless the acceptance is expressly made conditional on assent to an additional or different terms. Whether the additional or different terms becomes part of the contract depends on whether or not both parties are merchants. Terms included. Because Article 2 provides that a contract can be formed even though the terms of the acceptance don't match the terms of the offer, Article 2 also has specific rules for determining what terms are included in the contract in such a case. These rules are dependent on whether both parties to the transaction are merchants. Contracts involving non-merchant terms of offer govern. If any party to the contract is not a merchant, the additional or different terms are considered to be mere proposals to modify the contract that do not become part of the contract unless the offeror expressly agrees. Contracts between merchants, additional terms usually included. If both parties to the contract are merchants, additional terms in the acceptance will be included in the contract unless they materially alter the original terms of the offer, such as by changing a party's risk or the remedies available. The offer expressly limits acceptance to the terms of the offer, or the offeror has already objected to the particular terms or objects within a reasonable time after notice of them is received. Note whether an alteration is material is a fact question. So just reading the bold again, both parties are merchants, additional terms are usually included unless they materially alter. Changing the party's risks or remedies available. There's two actual definition words that define what is material. Written them down recently. Hardship or surprise. That is how you define material in this circumstance. The offer has already objected or objects within a reasonable time, or the offer is expressly limited to the terms that were sent with the acceptance. So I'm not going to go through this whole decision tree because it's clear they're included unless they materially alter or the acceptance, the terms are expressly limited to what is conveyed in the acceptance, or the offer has already objected or objected within a reasonable time. So that is really what can knock out the new terms. Note, different terms may or may not be included. If there is a split of authority over whether terms in an acceptance that are different form as opposed to in addition to the terms of the offer will become part of the contract. Some courts treat different terms like additional terms and follow the test set out above in determining whether the terms should be part of the contract. Other courts follow the knockout rule, which means that conflicting terms in the offer and acceptance are knocked out of the contract because each party is assumed to object to the inclusion of such terms in the contract. Under the knockout rule, gaps left by knocked out terms are filled by the UCC. So different terms will become part of the contract. But additional terms will not. They'll be knocked out.
Would you relax?
Merchant's confirmatory memo. A merchant's memo confirming an oral agreement that contains different or additional terms is also subject to the Battle of Forms provisions. Contains different or additional terms is also subject to the Battle of Forms provisions. That's your merchant's confirmatory memo. I don't know how that got here. Moment of mutual assent uncertain. In situations in which it cannot be determined with certainty which specific communication was the offer and which the acceptance, but the parties act as though there is a contract, the UCC considers this a binding contract even though the moment of its making is uncertain. When effective. The mailbox rule. Acceptance by mail or similar means is effective at the moment of dispatch, provided the mail is properly addressed and stamped. Unless one of these exceptions applies, the offer stipulates the acceptance is not effective until received, and an option contract is involved, and acceptance under an option contract is effective only upon receipt. The offeree sends a rejection and then sends an acceptance, in which case whichever arrives first is effective. The offeree sends an acceptance and then a rejection, in which case the acceptance is effective. That is, the mailbox rule applies unless the rejection arrives first and the offer detrimentally relies on it. So, this is not difficult, but there is a chart on page 28. Just see when we get to the end of this section, if it's coming up soon. Page 2930. Okay, the end of section 2 is actually in 3 paragraphs. So, starting with acceptance by unauthorized means. An acceptance transmitted by unauthorized means or improperly transmitted by authorized means may still be effective if it is actually received by the offerer while the offer is still in existence. Unauthorized acceptance, huh? Bilateral contracts formed by performance. If a contract is not formed by the parties' communications, but they begin to perform as if they formed a contract is formed. And auction contracts. The UCC contains some special rules regulating auction sales. A sale by auction is complete when the auctioneer also announces by the fall of the hammer or in another customary. I never read any of this in the book. Unless the goods are explicitly put up without reserve. With reserve means the auctioneer may withdraw the goods at any time until he announces completion of the sale. So Module 3 is about consideration. It's going to be at least 3 pages. My computer is going really slow. So it's at least 7 pages. And then Module 4 about requirement that no defenses exist. It's going to be a little bit more important section. Defenses that are based on the lack of capacity. That's 2 pages at least. 3 actually. Duress and undue influence is included with that, as well as intoxication. Absence of mutual assent, that is going to be mistake is in that section. Misrepresentation is in that section. That'll be 3 more pages. Then absence of consideration and public policy defenses and unconscionability. Statute of frauds. Hopefully that will bring us the end of Module 4 relatively soon. Are there any other defenses? They're talking about remedies within this section. And thus, Page 58 will be the end of module 4.